If you have an old removal order, you can still apply for Biden's Parole-in-Place program, and you might even be able to become a permanent resident. That's what we're going to be discussing today. So, two preliminary things. First of all, if you are actively being deported, if you're currently in removal proceedings and have a case pending, you can still apply for Biden's Parole-in-Place program, and it's probably a good idea to do so. It might end up helping you close your case and get prosecutorial discretion. It's a case-by-case determination. You should talk to your lawyer about that. If you don't have a lawyer and you're in New York, you could talk to me about that. The other thing is, if you have an old removal order, and I've had a lot of consultations with people with this exact fact pattern. They have a removal order from like 20 years ago. They're married to a US citizen. They meet all the other requirements, but they don't know if they can apply. And more importantly, they're afraid to apply because if it gets denied and then the next president is Donald Trump, they want to know, am I going to actually get deported from the United States? So that's what we're going to spend most of this video talking about. As a preliminary matter, if the next president is actually Donald Trump, there's a good chance that this program is going to come to a rapid halt. And we don't know what's going to happen with the applications that were already pending. My guess is that the applications that were pending will continue to be processed, but that's just a guess. We don't really know what's going to happen with that. So if you want to reduce your risk, and this is the situation you're in where you have an old removal order, you might want to wait until the elections in November to decide whether the risk is worth the possible benefits. But let's say you definitely want to apply for the Parole-in-Place program and you want to try to become a permanent resident through your US citizen spouse. What would the process look like? The first step is we need to get your application for Parole-in-Place granted. USCIS indicates that there will be a rebuttable presumption of ineligibility if you apply with an old removal order. What that means is that the default position is that you're ineligible, but you can overcome this by submitting evidence that USCIS can use to exercise favorable discretion. For example, I would submit evidence that you're a good person, that you've been paying taxes, that you have substantial ties to the United States. Maybe you have US citizen children, maybe you're a member of your church or community and you can get letters of recommendation. All of this stuff will be considered by USCIS and we can use it to overcome the presumption of ineligibility. So if we apply for parole and your case is granted, that would then fix your illegal entry. We would then need your US citizen spouse to file an I-130 family petition for you. And once this I-130 family petition has been approved, I would then try to reopen your old deportation order because even though your family petition is approved, you cannot apply for adjustment of status or a green card inside the United States if you have an old removal order, except for rare situations where, for example, you've entered the US as an arriving alien. Doesn't apply to most people who have removal orders. So after we've fixed your illegal entry, we need an approved family petition. And the reason for this is I'm going to need to reach out to the Department of Homeland Security attorney for your deportation case and ask them to join our request to reopen your case. If a certain amount of time has passed, usually the only option we have is for both parties to jointly request that the case be reopened. So I and the Department of Homeland Security attorney will need to jointly ask the immigration judge to open the case. And the Department of Homeland Security needs to exercise favorable discretion in this situation. They usually want to see that you have a clear pathway to permanent residence and that the only thing holding you back is the old removal order. So they want to see that you've entered the US with inspection, which the parole would fix. They want to see that you have an approved family petition. And then the last step is the application for permanent residence. So if you have these two, sometimes they also want to see that you have someone who can sponsor you for an affidavit of support. So we send everything to them. We show them that you're a good person, that you've had no criminal history, and if the policies are favorable at that time, which largely depends on the president, they will join our request to reopen your case. If that happens, we can then reopen your old deportation case, get the case dismissed or terminated, and then apply for adjustment of status with USCIS. So this is very doable, but a couple things you need to consider. First of all, it depends largely on who the president is. For example, the last time President Trump was president, for the last 2 years of his presidency, the Department of Homeland Security was not approving any requests to reopen cases. It was just a black hole, and we had to wait until he was no longer in office to submit these requests. Currently, right now, we can submit these requests, but it can take up to 10 months in New York, and in other cities it might take longer or shorter. I don't really know off the top of my head, but if it takes 10 months and I'm filming this video in September, the president will definitely change by the time the Department of Homeland Security makes a final decision on whether to join our request to reopen. So there is some risk involved there. So just a quick recap, the process is get paroled, get an approved family petition, and then apply to reopen your case. We need to ask the Department of Homeland Security to join our motion to reopen your removal proceedings, and then terminate or dismiss the removal proceedings. That will fix your deportation order, and then we could submit an application for adjustment of status with USCIS. There could be major complications with your case. This is just one example of a really clean case where the only thing holding them back is an old removal order. All right, guys, that's it for today's video. If you have any questions, put them in the comments below. If you're in this situation and you need any assistance, or you want to consult with me about any family-based immigration topic, you can view my consultation information in the video description below. Otherwise, I'll see you guys next week for another video.